Global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome to Global Happenings Today YouTube channel. Some days back, really, I think 48 hours ago, Nnamdi Kanu's case was heard and he was discharged, although the federal government said he was not acquitted. The lawyer, that's Ifeanyi Ejiofor, had actually made some very strong statement that the federal government ought to be releasing Nnamdi Kanu. Well, as they speak, they have decided to storm the DSS, which is actually the executive arm holding on to Nnamdi Kanu. Let's find out in a moment what they intend to do or what they arrived at, judging the fact that a lot of his followers and supporters are expecting that Nnamdi Kanu ought to be working freely, at least before the issue of Supreme Court comes into bear. At least let him be set free for the now to obey the court injunction. Well, before going to the newspaper, kindly subscribe to our channel by clicking on the red subscribe button. Beside it, you'll see a bell notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube. Well, about 72 hours after being set free by the Abuja division of the Court of Appeal, leader of the indigenous people of Biafra, Nnamdi Kanu is still being held in the custody of the Department of State Services. But the senior counsel for Kanu and lead counsel for the indigenous people of Biafra, that's Ifeanyi Ejiofor, said that the legal team will be formally approaching the DSS headquarters on Monday when the enrolled order of court and judgment of the Court of Appeal, which would be available for immediate compliance. While citing legal authorities, he said the freedom of Nnamdi Kanu, which was his fundamental and constitutionally guaranteed right, could not be stayed. Should the government and its security agencies refuse to release Kanu, he said far-reaching extant legal remedies, including reporting Nigeria to international agencies, will be activated to ensure immediate compliance with the court order. Ejiofor said this in an interview. It was reported that the Court of Appeal Abuja Division had on Thursday freed Kanu of the terrorism and treasonable felony charges preferred against him by the federal government. The three-member panel of justices of the Appellant Court had, in the judgment, set aside the judgment of the Federal High Court Abuja, which quashed 8 out of 15 court counts preferred against Kanu. The Appellant Court, in the unanimous judgment delivered by Justice Oludotun Adefunpe Okojie, declared as illegal and unlawful the abduction of Kanu from Kenya to Nigeria and squashed the entire 7 charges retained by the trial court against him on the ground that the federal government breached all local and international laws in the forceful rendition of Kanu to Nigeria, thereby making the terrorism charges against him incompetent and unlawful. But Ejiofor, who expressed optimism that Kanu will be out of prison today, advised the President Major General Muhammad Buhari, retired, to do the needful by obeying the court order. He said, and I quote him, It has been my position that the federal government has a right to appeal to the Supreme Court, which is a constitutionally guaranteed right. But the only impediment to the exercise of that right is that the federal government must first of all comply with the court of the learned justices of the Court of Appeal, which discharged Nnamdi Kanu and prohibited further indictment or commencing any fresh criminal charges against him. It is a settled law, as has been held by the Supreme Court in plethora of cases, including the Apex Court's decision and the case of Chukwuemeka Odumegwu Ojukwu versus Lagos State Government, that an appellant will not be in contempt of an order of a lower court and approach the Supreme Court in search of equitable remedies to stay execution. It is more so when, by the effect of the judgment of the court appeal under reference, emphatically set aside the order of the lower court and the frivolous charge which had hitherto legitimized his detention from June 29, 2022, they are now terminated and became extinct on October 13, 2022. Furthermore, the freedom of Nnamdi Kanu which is his fundamental and constitutional guaranteed right, cannot be stayed. Mazi Nnamdi Kanu is yet to be released, though we will be formally approaching the State Security Services headquarters on Monday with the enrolled with the enrolled order of court and judgment of the Court of Appeal, which will be available on Monday for immediate compliance. We expect to have Mazi Nnamdi Kanu released today to us, being October 17, 2022. The federal government is yet to file any appeal against the judgment of the Court of Appeal as at today, but as I had earlier stated, the federal government must first of all obey the order of the Court of Appeal and release Mazi Nnamdi Kanu, who has been discharged by the Court of Appeal, before challenging the judgment before the Supreme Court. It is our position that in unlikely event that the federal government of Nigeria fails to obey the Court of Appeal discharging Mazi Nnamdi Kanu, we will activate far-reaching extant legal remedies to ensure immediate compliance, which remedy may not be limited to resorting to domestic legal remedy, but will be extended to reporting the federal government of Nigeria heinous conduct before the relevant international agencies, foreign institutions, and government. Other legal remedies available to us will not be disclosed here. President Muhammadu Buhari has said on various occasions that he would not interfere with the judicial process, and that is the court that would set Mazi Nnamdi Kanu free. The Court of Appeal, the penultimate court, has set Mazi Nnamdi Kanu free. It is now time for President Muhammadu Buhari to keep to his word and ensure that Mazi Nnamdi Kanu is released without any further ado. While setting Kanu free, the appellate court agreed with counsel for the IPOB leader Dr. Mike Ozehume, senior advocate of Nigeria, SAN, that Kanu was illegally abducted and extraordinary rendition from Kenya to Nigeria against both international and local laws. By illegal abduction and extraordinary rendition of the appellant, there was a clear violation by the respondent to international treaties, convention, as well as the African Charter on Human and People's Rights, the court held. The appellant court said the federal government, having flagrantly breached the fundamental right of Kanu, lost the legal right to put him on trial, adding that laws were meant to be obeyed, that the federal government has no reason to have taken laws into their hands in the illegal and unlawful way the matter of Kanu was handled. The failure of Nigeria to follow due process by way of extradition process as prescribed by law, it is said, was fatal to the charges against Kanu, and further held that the failure of the federal government to disclose where and when the alleged offences brought against Kanu was committed was also fatal to the terrorism charges and made them look liable to dismissal. By engaging in utter unlawful and illegal acts and in breach of its own laws in the instant matter, the federal government did not come to equity in clean hands and must be called to order. With appalling disregard to local and international law, the federal government has lost the right to put the appellant trial for any offense. Treaties and protocols are meant to be obeyed. No government in the world is permitted to abduct anybody without following due process of extradition. Nigeria is not an exception or excused. Nigeria must obey her own law and that of international so as to avoid anarchy, the court held. The panel also held that the trial court lacked jurisdiction to handle the charges against Kanu as he was not properly arranged before the court. The panel, presided over by Justice Jumai Hanatu, also held that the offences Kanu was alleged to have committed happened in Kenya and not in Nigeria. Justice Binta Nyako of the Federal High Court in Abuja has said in her judgment that counts 1, 2, 3, 4, 5, 8, and 15 shows some allegations which the IPOB leader had to answer. But Kanu, through his team of lawyers led by Mike Ozehume, senior advocate of Nigeria, SAN, filed an appeal marked CA/ABJ/CR/625/2022, praying the court to squash the remaining 7 counts for being devoid of merit. Whoa, that was a lot.